Any mention?
Yes.
May I please, Your Lordship? I beg to mention item number 8, my lord.
One second. Bishop has been deleted. This left. Number?
8, my lord.
Yes.
My lord, let the matter may come after the winter vacation, my lord.
No objection, Your Lordship. List after vacation. Yes.
Highly obliged. May I please, Your Lordship? Your Lordship, I beg to mention item number 7. Your Lordship, I'm praying that the matter may come up after winter vacation, Your Lordship.
No objection, Your Lordship.
Yeah. This also.
Highly
Same,
obliged,
same
Your Lordship.
order. Yes.
May it please, Your Lordship, I beg to mention item number 6.
Yes.
Lordship, I pray that this matter comes after vacation.
No objection, Your Lordship.
Yes.
Applied.
Highly obliged.
Supplementary causes, item number 1.
Yes.
So this is a matter emanating out of the Lokayukta proceedings. I have been subjected to Lokayukta proceedings and thereafter a proceedings before the special court. Despite the fact my name never featured in the complaint, there was no mention of my name in the initial complaint which was made to the Lokayukta. None of the procedures which are, my lords, enumerated in section 20 of the Lokayukta Act were followed qua me. My name features for the first time in the charge sheet. And no allegations, my lords, specific allegations were qua me.
Who was the party before Lokayukta? Who
My
was
lords,
the party
your
before
lordship,
Lokayukta?
see the complaint at page 87. There were 3 people who were party to the complaint
Page
before the
87.
Lokayukta. Page 87, my lords.
Yes.
My lords, the complainant is Mr. Nilbert C.H. Marak and the respondents are Ismail Marak, Ubon Sangma and Nixing Sangma.
You are not there.
I am not. I am one Mr. Boston Marak, my lords. So I am not a party, and for the first time, my lords, my name features at page 138, which is the charge sheet. There is, my lords, a procedure laid down in the Lokayukta Act from the complaint till the charge sheet,
When
whereby
Lokayukta passed the order? When
my
was the
lords,
date of the order of Lokayukta?
18/5/2023 is the order, my lords. This is at page 145. And my name, my lords, features.
2023. Yes.
Yes, my lords. My name features, my lords, at item number 1.
Yes.
Despite the fact there was no complaint against me, nothing, no opportunity of hearing was accorded to me in
But this
accordance with the law.
order, and then when this matter was forwarded to the special court, special judge?
Yes, my lords, by subsequent, my lords, document at 147, page 147, dated 19th May 2023.
And what is the stage of trial?
My lords, it is at the stage of framing of charges. I have put the case status as well.
No, but then this order was passed quite some time back, isn't it? 2023.
Yes, my lords. Now the difficulty is, my lords, if your lordship sees annexure P 35 at 156, because of these proceedings, which, my lords, I have my objections. I have taken, my lords. The Lokayukta has no jurisdiction over Garo Hills Autonomous District.
There
That
is
is my
some order
prime.
passed by this court also before this. No,
Yes, my lords. In a similar matter, your lordship has been pleased to stay the proceedings before the special court.
no, but then we were very late in coming. We'll issue notice.
No, my lords. In this case, my lords, kindly sees 156. page 156. Now, my lords, first of all, there is no jurisdiction of the Lokayukta over GHADC, which is a autonomous institution under the Constitution. Then I have not been given any opportunity of hearing. Now, my lords, Enforcement Directorate is after my life, my lords.
So
156. At page 156,
yes,
your
no.
lordship.
The matter is now your matter is charge sheeted now.
My lords, yes, my lords, matter is charge sheeted, but in this case, I have not been given a hearing also, my lords, in accordance with the Lokayukta
No,
Act. Kindly,
what enforcement directorate has to do here?
my lords, based upon the predicate offence, they have started proceedings, the
They are
investigation.
separate. Is there anything to show? Is there anything to show that they have started on basing on this order of Lokayukta?
156, my lords, 156, page 156.
Yes, but then does it say that is based on the?
My lords, kindly cease. In Directorate of Enforcement has conducted a first search operation in West Garo Hills on 4th December 2025 under the provisions of PMLA
Yes.
in connection with
That is
misappropriation
different.
of.
You are not
No,
being
my lords,
charged under PMLA. Your proceeding here before special judge is not under PMLA, isn't it?
no, it is not under PMLA,
See,
but
ED
I am
is why
saying,
you
my
are
lord,
connecting ED with this. What is your prayer
no, my
with
lord,
this? What is your prayer
it
before
is.
this?
No, my lord,
What is your
it
prayer
is,
in
my
this
lord, it
petition?
is for a total. Kindly sees the second paragraph at 156. It is for
Yes.
this very case.
Yes.
Out of a total allocation of 28.66 crores, members of the committee in collusion with the certain contractors diverted the funds. And
Yes.
kindly sees me the charge sheet page that I had indicated previously at 138.
You see, but the ED has not launched any investigation in pursuance of order of the Lokayukta. They are doing it of their own, isn't it?
They are doing it
Yes.
on their own. But
Just
what
come to the
I'm
prayer made in this writ petition. Where is the prayer in the writ petition?
yes, my lord, yes, my lord.
Yes, page 21, probably, isn't it?
Yes, my lords.
So you are seeking stay of that case.
I am seeking only for the predicate offense, my lord. I am just saying that because of these illegal proceedings, I am being further harassed. That's it.
Yes, who is appearing for the state?
I'm appearing for this. They are private respondent. Let the notice be issued and this matter need
What
to be
about
heard.
his interim prayer? What about his interim prayer? You
Interim
have
prayer, we
objection?
have a strong objection. This is the case of 2023. So they have come at a very belated stage, Your Lordship.
So will your interim prayer will be considered on the returnable date, Mr. Pandey?
My lords, what I am suggesting, my lords, in this case, my lords, in similar facts, same allegations I have raised against GHADC, kindly sees, my lords, I have been protected, my lords, in a similar situation. By your lordship, my lords, kindly sees the order which has been passed at 154, my lords, page 154. I am seeking, my lords, parity in terms of that order, my lords. I am also saying that GHADC has no jurisdiction.
And that is all right. But then the thing is that, you see, this is a belated approach. So it will be proper to hear the private respondent before any order is passed.
My lords, till the next date of hearing, because my lords, I am saying, my lords, kindly seize this order. The learned para 3, learned counsel of the applicant question the legality and validity of proceeding against the applicant Lokayukta in special PC case 1 of 2024. It is submitted that Lokayukta has no jurisdiction over GHADC.
See the subsequent paragraph, there was no objection by the state.
My lords, there is no point, my lords, in this case where I am being prosecuted against in a case where there is no jurisdiction. My lords, those proceedings have to be stayed. And my lords, there will be nothing new, my lords, which will come. All these matters, my lords, are similarly placed. And this is just one of the orders, my lords. I can indicate
We'll
three
keep
more.
it next day. You
were
try,
similar orders.
you try it before vacation match. We'll list it to be we'll order it to be listed before vacation match. We'll issue notice now.
My lords,
Since it is opposing. Okay.
Because there is no,
State
the
needs some time
question,
to basically to respond. Earlier, what happened? You raised those grounds, but then there was no objection to it. Now, since the objection has come, we should.
because the objection would be
This will
the
be considered
situation here is,
on the returnable date, Mr. Pandey.
Milos kindly sees the third paragraph at 155, the submission of the learned additional advocate general.
Yes.
grant some time to obtain necessary, no serious objection has been raised. Because it's a similar situation.
No,
It's
no.
a similar
Here's the
situation.
objection. Here is the objection by the GA.
Because there cannot, in this situation, because it is identically placed. And
Maybe
on the next
it
date
is
of hearing,
identical, but then it is not not the same case, isn't it?
yes, because there is no merit to the objection which has
That is
been raised.
we'll consider it on the returnable list. Hard.
Well, what I'm proposing is that till the next date of hearing, let it be protected. Let me be protected.
That becomes an interim order. We'll pass the order on the next day. We'll just see.
No, then your lordship may place it before the vacation bench, my lords.
Okay. Yes. Heard, Mr. Pandey. Just in the main case. You have filed a miss case.
Yes, my lords, I have filed a miss case.
Yes. Heard, Mr. Pandey, on counsel for the petitioner. Issue notice. What is the vacation bench?
Till then, there's no specific order has been passed. Special notification has been passed.
That
I
is-
think most probably 29, but 29 will
No,
be till
before
to
that, there are two things, two vacation bench. And then other benches. There is no other bench. Vacation bench is for any judge can take it up. There is on 29th December also. Okay, just heard Mr. Pandey, Canonic Counsel, the petitioner. You should not, but then if Mr. Abraham, in a similar case, if there is an interim order passed, then why not here?
But in this case, what happened is that they came at a very belated stage. This was a 2023 case. Now it's already going to be 2 years, Your Lordship. If they really agree by that order, then they should have come early before this honorable court.
But that is not the case, because here there is no basis to any proceedings.
let this
That
matter
is the
Take
case.
instruction, just
I'll take instruction,
we'll just order it to be listed for before the vacation bench for considering the repair, isn't it? Okay, this just issue notice returnable in 3 weeks. Mr. Abraham, Land Council appears on behalf of the respondent number.
1, Your Lordship. Respondent 2 is a private respondent, Your Lordship.
Staff petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. List after 3 weeks and come to the interim prayer.
Yes. Hello, Bless, Your Lordship.
Just a minute. We have to pass order in this case. In this case, you just say list this application before the you take instruction on this thing or the interim prayer,
Yes, Your Lordship.
whether you at all really object or not, because on the earlier occasion there is no objection by the state.
I'll take instruction, Your Lordship, in that case.
I can produce even orders of 2023 which have been challenged, and there hasn't been any objection, my lords, in respect of that, because it's a question of legality law in this case.
Anyway, you see, like since they have raised objection, we should give them some time,
Yes, my lords.
at least to respond.
Yes, yes.
Let us see what happens on the next day.
Right.
Just say, in this case, this is an application seeking stay of the proceeding of the special PC case number 1 of 2023 pending before the special judge West Garo Hills, Tura. Stop. Mr. Abraham, Land Council, appearing for the state, prays for some time to obtain necessary instruction in the matter. Oh, there is a private respondent also.
Yes, my lords, this is a private response.
Just say, halt, Mr. Pandey, Land Council for the petitioner. Issue notice on the interim prayer made in the application. Mr. Abraham, Learned GA APS for the Suno 1. Mr. Abraham, Land Council, Learned G. Appearing was the state respondent. Praise for and granted 1 week's time for taking necessary instruction. Stop. The petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. List before the next available vacation list before the vacation match for consideration of the interim. List before the next available division vacation bench for consideration of the interim. Yes.
Obliged.
Item number 2.
Yeah, please.
Maybe please, Your Lordship.
Yes.
This is a matter for quashing, Your Lordship, of the FIR and the proceeding under Section 436 of the, and it's for burning of a house. In fact,
436.
436 IPC.
It's a very
So-
serious charge.
So burning of a house, but there is nothing against me. In fact, it has come as a for a legal aid, Your Lordship. I'm moving as a legal aid counsel
okay.
from that.
You are seeking quashing of FIR.
Yes, quashing of the FIR and the proceeding.
FIR. When is the date of the FIR? FIR is 24th till 2024.
Yes, Lordship.
So it is more than 1.5 years.
Yes, yes, Lord.
Investigation must have progressed by now.
Must have progressed, but since my learned senior has come for quashing, my lord, the complainant should be made party.
Complaint is not a party here.
Oh, my lord.
How can it be? Oh yes, complainant is not here.
Not a party. I'm sorry. Should
So what you will do?
I may be allowed to incorporate the complaint and
How you will do it again? They say, okay. So it is just say this is petition. So what we'll do? We'll issue notice after the you implement the complainant as a party, or
I'll incorporate the complaint as a party because from the
then
legal.
after you implement complaint as a party, then we'll take it up for motion or what?
Yes, that you
That'll be better, my lord.
Then just it is pointed out by the learned senior G. Oh, sorry, learned PP. That though the petitioner has sought quashing of the FIR dated 24/3/2024 in this application, comma, the complainant has not been made a party. Mr. Mahato, Lord Senior Counsel, appearing for the petitioner, prays for God. Not of some time to implement the complainant as a party respondent to the party respondent in this petition. Prayer allowed. List after.
Vacation.
Then now vacation is starting again. I have to.
List after 2 weeks.
I'll do that.
Much obliged, Lordship.
Item number 3.
Deeply obliged.
We'll issue notice only after you do that.
Yes, I'll do that.
It will be listed for motion in that case. Yes.
We plead the writs.
Yes.
Well, it's a limited issue here. What had happened is, I am a manufacturer of these products, like Maggie, etc. Not Maggie, Maggie, just a generalized term. Uh, so,
Maggi means noodles.
noodles, noodles, etc.
Okay,
but the local variety.
Yes.
Now, it's for the purposes of this manufacture, we buy a lot of these raw materials from various companies. Now, one of the raw materials that is used is chili powder, Chili powder.
Chili powder.
So, in my case, the chili powder is purchased from a certain company called Vaidehi Industries. So, there was a surprise inspection in my premises by the food safety.
Where your manufacturing unit is situated? Here?
In Meghalaya,
But then you procure chili from outside.
it's chili powder because it's naturally, it's not a local product, so we have to buy it from outside. So, there was an inspection. So, in the process of inspection, they went about inspecting all the raw materials that had been procured. So, in the chili powder, there was some adulteration that was found. So, we pointed out to the authorities that yes, and these are the invoices, these are the vouchers under which from where it has been purchased, when it has been purchased, quantity which has been purchased. In spite of that, now I am being prosecuted under the Food Safety Act. Whereas, Vaidehi is not being prosecuted, which is the limited issue why we are here before your lordships.
When you prove your innocence in the trial, what is your problem? See, the question will be that who made the adulteration? That will be a thing. It may happen like that you procure thing from outside and make the mixing here.
No, the adulteration is in the chili powder. It's not in my product.
That is okay. You can bake the thing here.
No, I can't, because it comes in packets. The chili powder comes in packed parcels. Now, what happens is, that is because now these are all through mechanized processes.
You are using that product, or is it not that you are?
As a matter of fact,
I'm sorry. This has to be by this thing. This is a food safety act.
Food Safety Act. I am simply saying, that if I did not have the valid vouchers
There are two different. Food Safety Act is there. Then Prevention of that thing.
Adulteration Act.
They're two different.
They're two different acts.
But then proceeding to be initiated as a CR case, isn't it?
Yes,
So complaint has been filed again.
We filed our responses with the authorities, we pointed out with all relevant documents showing that it has been procured from somewhere else.
Where is the order?
The complaint.
Issue of process.
I'm sorry,
Where is the order by which process was issued?
That your lordships would find at page 84,
What is the stage of the case now?
It is at the stage of precognizance,
Then where is the cause of action then?
No, I am not on that.
Court has not taken any cognizance.
I am saying, the complaint cannot be against me in the first place. If at all, it has to be against Vaidehi.
That thing court will take care of. Cognizance has not been taken.
I bow down to
That
that.
is this extra layer of protection. This provision is introduced for this kind of things only.
Lordships.
So you think.
Your lordships will kindly appreciate, that once we are dragged into one of these proceedings, what happens?
It is pre-cognizance, means nothing. The court basically wants your version before court decides to take cognizance. Place your version as you are placing this version before this court. The same version has to be played there only.
Your lordships will kindly appreciate whether in the first place, because the court would have applied its mind before issuing notice to in this matter also.
Mr. Paul, in this at this stage, this court is not at all. We thought that the process has been issued after taking of cognizance. That has not been done.
No, it is not at the stage of it has not reached the stage of cognizance. May grant us that liberty then, to raise these issues before the learned.
That is even not required. Here it is said.
No, because
it's paragraph 7. So opportunity hard is to be awarded to the accused. So that is
no, that's okay, but that should not be with regard to the other issues, technical issues. I am saying that on the merits of the matter.
See, the 223 has no barrier in it. You can raise any plea. If you say
I'll
that
just
you are
point
innocent,
out. I'll point out 223,
Yes, definitely. protection against frivolous proceedings against him. Vexatious, frivolous proceedings.
That proviso that has been inserted simply says, my lords, no cognizance shall be taken of an
And some-
offence.
see the date, Mr. Paul, 23/7/2025 for appearance. Next, see paragraph 10 of this page 84.
My lords. After that, the matter is not proceeded, my lords.
How do you know? It is
No,
not-
we have
see,
appeared over there, my lords. We have appeared over there. It's not that we have not appeared over there, my lords. We've appeared before the
Finish
learned.
there. If you do not get released there, approach this thing. If you appear there, what is the problem in placing
Then
this?
my lords may permit me to withdraw this with liberty to, my lords,
Yes, yes.
place my relevant facts
Yes,
before
yes,
the
yes.
concerned trial court.
Yes. Yes. After arguing for sometimes. State is not a party here, isn't it?
State is not a party, my lords.
After arguing for sometimes. Come on, the learned senior counsel for the petitioner. The praise for withdrawal of the matter with the liberty to raise, with the liberty to the petitioner to raise the contentions made in this petition before the trial court. Paragraph B of the submission. This petition is dismissed on withdrawal with liberty as proof. You raise it. Raise it.
My lords.
For
Obliged.
Yes, Mr. Thapa.
May it please your Lordship. Lordship, here the small issue that falls for consideration of this honourable court is whether
Small issue.
whether the
Very small issue.
small
but then
issue,
even
my
that,
lord.
that has brought to
it's
to
in
High
fact
Court.
it's already a settled issue, my lord.
Yes.
Here the only issue that crops up here, my lord, is whether a proceeding under 145 would
CRPC. Yes.
CRPC, my lord, would lie when there is a civil suit pending and there's an order passed in that respect.
Ram Sumer Puri,
Right, my lord.
1985.
Right,
But
right.
then thereafter some other decision is also there.
There are there, my lord, numerous. My lord, I'll take your lordship to the facts of the case. My lord, I'll take your lordship straight to page 59, annexure 1 of my petition, my lord.
You are first party or second party in a 145 proceeding?
145%, I'm the second party, my lord. Page 59, my lord, annexure 1.
50?
59.
Only 59, 59.
59.
At 150. Yes, sale deed.
Yes, my lord. Now, by virtue of this sale deed, my lord, which is a registered sale deed, my lord, I came in, I became the owner of a certain plot of land.
Is it required to determine?
Beg your
You
pardon?
know 145.
My lord.
It
But
has no
why I'm saying
relation-
this?
No relation with
My,
ownership.
no, why I'm saying this, my lord, I'll take your lordship to the facts of the case later on. Why I'm saying this is important, my lord, by virtue of this sale deed, my lord, I came in possession of a certain property way back in 2017. Now, my lord, may
You want
kindly...
to say that this sale deed proves your possession over the land?
No, I am in possession. I am in possession by virtue of this sale deed, my lord.
So far as the 145 is concerned, the possession has to be physical possession.
Right. Yes,
It
yes,
cannot
my lord.
be, you see,
On a
possession
documentary
by virtue of
possession.
ownership.
Lordship has also dealt
Cannot
with
be
this
constructive possession.
issue earlier in a different proceeding, my lord. What I'm saying here
That
is,
is what the law says.
now, my lord, what happens here is, my lord, 2017, I entered into the sale deed. I became the owner of the property. I came into possession. I, my lord, rented out property. I built up the structures there and I rented out property on the said property. Now, my lord, what happens, interestingly, my lord,
Now you have a dispute with the tenants. No.
no, I have a dispute with, my lord, one of the sister of one of the seller. Now, who has come up in the picture later on at a belated stage. Now, my lord, I'll take your lordship to page number 12.
1, 2.
Sorry, not 12, my lord, 80, sorry, inner page 12.
Another
Now,
say?
my lord, sometime in the year 2024 again, my lord, may kindly note, in 2017 I entered into a sale deed. My lord, 2024, the sister of one of the seller, my lord, files a case against me. My lord, saying that the sale deed was fraud and so on and so forth.
Where? Is, what case?
My lord, suit for title suit for declaration and possession.
Okay.
Declaration and possession, she filed a case in the court of the civil court before the at a Nongpo court. Now, my lord, may kindly see at page 80,
80, yes.
80, my lord, this is the schedule of the property. This is the same as what I have shown in the sale deed. Now, my lord, may kindly see the prayer
Where?
made in the said suit.
Anyway,
My lord-
see,
Now, what has happened?
we can cut short. You see,
I'll cut short, my lord. I'm sorry.
Just a minute. In 145, we may not have to go to that.
Correct.
Just tell us in the suit whether both of you are parties.
Yes.
Both of you are parties. So there is no dispute.
In fact, my lord, the suit is initiated at her behest.
Okay.
The complainant before the executive magistrate also. Now, what has happened, my
Now,
lord?
who filed this complaint under 145?
She only filed, my lord. The one who plaintiff only filed, my lord, she failed to obtain any orders in the civil suit. She went on to go and file the complaint
There
before
was
the.
an interim prayer in the civil suit.
Yes, my lord.
And that
My lord,
was
may kindly
rejected.
see.
Rejected.
Interim prayer is at page 94. I mean, the order is at page 94.
Page 94.
My lord, on miscase being moved by the plaintiff, who is the first party in the before the executive magistrate, my lord. There's an order of status quo.
Yes.
My lord, may kindly see on the last paragraph. On perusal of the material on record, having heard the counsel for the petitioner and in the interest of this case, parties to maintain status quo
Yes.
as regard the suit property pending disposal of the instant suit. Now, my lord, she failed in here, and then she started to again trouble me, my lord, because
She has not totally failed. She has got the order of status quo. isn't it?
yes, my lord, here the status quo is for both of us. Now, my lord, she realized that this order is not helping her in any case.
So this
My lord,
status quo order is prevalent.
It's prevailing, my lord, and she is in continuous breach of that status quo order. We file a case under 39(2)(a). We file a case under 39(2)(a).
Violation of the interim order.
Violation of the interim order.
Yes.
My lord, there also certain orders are passed by the learned trial court. My lord, may kindly see page 106. From 105, the order starts from 105.
Yes.
Now, my lord, may kindly see, I'll take your lordship to the operative portion at page 106. Sin miscase number 10 of 2024, wherein wide order dated so-and-so status quo is directed to be maintained until next date, and thereafter this court wide order so-and-so in the miscase has extended the status quo order until next date returnable date. Considering the material, let notice be issued to the opposite party, issue notice to the OP petitioner to take steps. In the meantime, both parties are to comply with the order dated so-and-so and so-and-so, passed in miscase number 10. So invariably, there have been an order by the competent civil court in
The
respect
violation
of
of the status quo order was brought to the knowledge of the court.
Yes, my lord.
And
And
that
she is
civil
seized of the
court
matter.
seized the
Seized
matter.
of the matter, my lord.
And civil court also has the power, if in case civil court finds that an interim order is violated, then civil court has the power to even seek assistance from police.
Yes,
to-
yes, of course, my
Isn't
lord,
it?
of course, yes. Now, my lord, having failed to yield any result from the other earlier proceeding, my lord, she went on to file this complaint before the executive magistrate under 167 of the present act, earlier 145. My lord. My lord, the complaint is at 107, page 107.
Yes.
Now, my lord, this is the complaint, and in this complaint, there was an order passed by the learned executive magistrate, which your lordship will find at page 123. My lord, in spite of the fact that, in spite of
Who is that magistrate? Which court?
Riboy district, my lord, executive
What
magistrate,
order is that page?
page 123, my lord.
Yes.
Well, CR put up today, peruse the matter and the documents attached therewith. Given the repetitive instance of trespass and provocative violence, there appears to be genuine possibility of threat of law and order as well as.
So
public
he
tranquility.
takes over the job of the civil court.
Yes, my lord. He usurped the powers of the civil court. Now, lord, so much so, my lord, he directs the Khanapura, OC Khanapura PS to submit an inquiry report to this court without fail before 9/12. Now, on 9/12, my lord, a report is submitted by the police, my lord, which is at page 164. Now, in the report, my lord, I'll take your lordship to the relevant paragraphs.
Is there any requirement for us to go to the report?
Not required, actually, my lord.
Is it not that the very taking of cognizance of the basis of the petition under 45 is wrong?
is
wrong
is
exercise
false.
of jurisdiction.
Absolutely, my lord.
Anyway, you see, like
I did not say anything
what
more.
you will say? When a matter civil court has seized the matter, how could the jurisdiction under 164,
167, my lord.
167
of the
be
present act.
exercised?
Maybe there was some application by the.
Can
But
even if
it
there is
can't
application.
actually in law.
See, madam,
it's only seized with the matter, the judiciary. Lordship.
See the interesting part in
Lordship.
this order. It is not that the magistrate did not know about the existence of civil court. It has been reflected in the order. It says that whereas the same has been made clear by willful disobedience of order passed by the honorable civil court. Now he basically acts over and above the civil court.
Lordship.
Can he? It appears that there is some jurisdictional error.
My lord, just to brief this honorable court, I think, if I'm not mistaken, there's a writ petition pending before the other court also with regard to FIRs.
That is
Yes, certain
concerning
FIRs.
one of the tenants of mine, my lord.
I am
Here for
For
representing the
respondent 5.
respondent number 5.
the
Yes, my lord.
okay.
Now, my lord, the party who had filed the civil suit. Now, my friend made a reference to a petition filed under Order 39-2A alleging violation of the status quo order. That petition was not filed by him, my lord. In fact, he has not even participated.
there is-
No,
the-
my lord, there has been, what has happened here is, my lord, what has happened here is, there has been a violation of the status quo. They have trespassed into the property, my lord. The property, inside the property, there is a company under the name of Resource Rubber.
Okay, even
My
if you
lord,
assume that
number
it's
5,
correct,
number 5 is the private, is the local director of Resource Rubber, my lord. There is no denying that there is a civil suit pending. Now, during the pendency of a civil suit, there were acts of criminal trespass, my lord. Criminal trespass with by using criminal force, my lord. Now, these 2 FIRs were filed before the Nongpo police station. The FIR before the Khanapara PS. That FIR was cognizance of the FIR was not taken. That compelled us to file to come to the High Court,
see,
my lord.
if you say that there is criminal trespass, you
My lord.
filed FIR under IPC.
My lord, we have done that.
145 cannot be
My lord.
drawn up. See this.
My lord, why this 145 was drawn up? Because,
see, Mr. Gautam,
my lord,
don't mind that court is interrupting you.
my lord, my lord.
You are a mature, seasoned lawyer, mature lawyer. You know that in
My
what
lord,
situation.
I am fully aware of the law, my lord. But my lord, is there a bar if during the pendency of a civil suit there is likelihood of breach of peace? Is there a bar for the executive magistrate to draw up a proceeding, my lord?
See, when there is an interim order passed by a civil court with regard to the same property,
And that interim order,
this
my lord,
civil court's order will have supremacy.
my lord, of
145 you do not lie. You may file case under IPC appropriate section of IPC.
my lord, under 145, if a person is wrongfully dispossessed, my lord, if a person is wrongfully
you
dispossessed,
show as a law, now burden is on you
my lord,
that despite pendency of a civil suit, 145 proceeding can be done.
my lord, let notice be issued, my lord. I will show that on the next date, my lord,
Do you have
because
that,
Yes, I have that.
these are subtle thing. You are
my lord, I am not on that, my lord. My lord, if there is the proceedings under 145 and I mean under the new Act 164 and 126 have very limited scope, my lord.
Yes.
As to the factum of possession, number 1, and if there has been a case of wrongful dispossession, then the magistrate can act and pass an order asking for directing restoration of the person who is wrongfully dispossessed. Now, here is a case where I filed a civil suit, my lord. I had filed a civil suit, and in that civil suit, a status quo order is passed, my lord. That status quo order is passed as early in May 2024, my lord. I am in continuous possession. There is a factory there. There is a factory there. Under name and style Resource Rubber. I am the local director, my lord. The factory is there, and I am there. The status quo order is there. On every date I am appearing. The court is extending the status quo orders. They have not entered any appearance. Then thereafter, on 21st, there is a first case of criminal trespass, my lord. So I filed an FIR. My lord, I filed an FIR. The police does not act on my FIR. On 22nd, my lord, armed people enter into the premises, break the CCTV cameras and everything. I filed a subsequent FIR, my lord.
Dangerous man.
Yes, my lord. The second instance, my lord, they are armed. They enter into the premises. They vandalize the premises, and they trespass into
this
it.
is not the
And then our workers who are there, they have been thrown out. My lord, we filed repeated FIRs. FIRs are no cognizance of the FIR is taken up. In the meantime, we went to the trial court. We filed a petition under Order 39, Rule 2A, alleging breach. And the order which my friend read out, my lord, was the order which was passed at our instance. Now, this copy of the order was also communicated to the officer in charge of the.
See, this status quo order was passed at.
Yes, my lord. It was passed at my instance, my lord. On the suit I have filed.
Just a minute. In this order was passed quite some time back.
Yes, my lord.
You
Quite
are
some time back.
You are satisfied with the order. You have not challenged it, so you are satisfied with the order.
My lord, the status quo order was passed.
Wait. Just
My
a
lord.
minute. Since you have not challenged it, so legally we can say that you had no grievance with that order.
My lord, I was in possession. Why will I have grievance, my lord?
Definitely, yes.
There was no interference now.
Was it not for you to file an application before the trial court saying that the status quo order was violated?
My lord, yes, I have done that, my lord. That is what my friend read out, my lord.
Yes.
The order, I have the copy of the order, my
Yes,
lord.
yes, yes. Now in that petition,
In that-
see, when you do it, some order is passed.
Yes, my lord.
Now, how can you go and approach the executive magistrate
My lord, what
for
actually?
getting a relief which apparently
Which a civil court can grant. My lord, the civil court had granted me relief, no doubt.
If you say that it has been done intentionally, then I will say that this is totally abuse of process of law.
Absolutely.
My lord,
Then, if it is done
my lord, it is.
intentionally, then
My
it
lord.
is abuse of process.
My lord, kindly see how the proceedings were initiated, my lord. My lord, all the FIRs that were sent to the officer in charge of the police station, copy of it was marked to the DC as
You
well.
understand the limit of jurisdiction here. You are not
My-
arguing
I-
before a read court here,
My lord.
bringing on all those things, police action here.
My
We
lord.
cannot do anything.
My lord.
The fact that there is a civil suit pending with regard to the same property,
My lord, I will
It's
still.
good enough.
My lord, I will still maintain, my lord, that even during the pendency of the civil suit, if there is a likelihood of a breach of peace,
give us law. Give us law.
my
Show
lord,
us law.
my lord, I am not armed with the law, my lord. If this matter is taken up, my lord, there is.
The matter, the
We are
position
staying
is.
this order. We will just come prepared on the next date. Not possible. This is too much. Totally.
My lord, since the police did not act, my lord.
You see, executive court cannot take over the job of a
No, my lord.
judicial court.
Absolutely. No, my
This
lord.
High Court will totally protect it if any attempt is done.
My lord, all I am saying is.
Fail to procure a judicial order, you go and execute to executive authority. You get this
My lord, all I am saying is.
preventive the provisions of this thing invoked, and then you pass some.
My lord, all I am saying is, during the pendency of the civil suit, there were instances, my lord, where there was the likelihood of breach of peace. Now, in such circumstances, if the executive magistrate, if the magisterial court has taken cognizance of these instances, given the fact that the police has not acted on the FIR, then in my humble and respectful submission, my lord,
Was there any? You could have made the civil court
my lord,
pass a direction
To the police.
directing the police to ensure that status quo. That
My lord,
can be done
my lord,
when
in that-
violation of interim order.
my lord, that prayer was made, my lord. But that prayer was
See,
made.
you have-
That was
you
there in
have-
the petition, my
You
lord.
have jumped from one jurisdiction to another. See, this is something wrong. This court doesn't appreciate that.
And my lord, since the police did not act,
entirely wrong.
my lord, since the police did not act, we file a writ petition. And today the officer in charge of the concerned police station has been summoned by the court, my lord. He's been asked to
That is
make a
all right.
personal
See, law will
appearance.
take its own
All right,
course. You may have a very good case on merits. But then
So,
your approach-
my lord, at this stage, I will pray that no interim orders may be passed, my lord.
19 is the
order
date, my lord.
cannot be allowed to remain in course.
There's multiplicity of proceeding, my lord, and the likelihood of orders passed in
See,
conflict are very
Mr.
high.
Thapa, multiplicity of proceeding also, if law allows it, permits it, there is
Yes,
no problem. in
that
it.
is correct.
But then 145,
Very limited.
Especially when the civil court has already taken
My lord,
cognizance of the subject matter.
And at
My
their
lord-
instance,
My lord, there is one more party here, my lord, who has not gone to the civil court. In fact, my lord, he has also encroached upon the land of. If my lord will kindly see.
Are you appearing for that party?
My lord,
my lord,
the person I am appearing for is a. My lord, what has happened here is there are two separate plots of land, my lord. Now, these plots of land has been leased out to Resource Rubber Limited. The person I am appearing for is the local director of Resource Rubber Limited. And where this trespass has actually taken place, my lord, a part of it falls within that. Within that.
Anyway, let the other party come. Let the other party come and approach the court. We'll see.
My lord, they have not even made that.
See, the problem is that you see.
My lord, there is a party who has not gone to the civil court, my lord. And that party has also filed an FIR, my lord.
That is okay. That party will take its remedy. This order will not bind that party.
But I am the, my lord, I am
This
the
order
power of
will
attorney
only-
holder of that party, my lord.
This order will only be with regard to the 145 proceeding, nothing else. That rest of all your options will be open. Your writ petition will proceed.
My lord, of course.
Your civil suit will
But
also proceed.
my lord, I'll still maintain that.
We fail to understand.
My lord.
If you say that there is a emergent kind of situation,
My lord.
civil court is still there.
My
You
lord.
go. Even if this case is fixed on February, also it will not bar you from approaching civil court again.
No, my lord, absolutely not, my
Then-
lord. I have approached, I have.
Then
I
why
have
you are
sought
going to the executive magistrate,
My lord,
asking him to do the job?
My lord, I have just brought to the notice of the executive magistrate that there are instances which are likely to distort peace and tranquility in the area. And I'll still maintain, my
I'll
lord,
just take
even
your
if there is a
lordship to-
pendency of a civil suit, my lord, even if the civil suit is pending, my
Anyway,
lord,
you just bring that show that law. So long you do not show this law, do not expect this court will.
I'll just take your lordship to one paragraph from the report, my lord, which speaks of the conduct of the private respondent.
On minutes, this court
She
has
has
nothing
even gone
do.
to the extent of bribing the police official to act on her behalf.
So this
That has gone on
allegation
report,
counter-
man. I need not say
allegation
anything on that,
counter-allegation
man.
will not do. Anyway, we'll just see. Yes. You filed a separate miss case or
My lord.
okay? All right, Mr. Thapar. Yes, madam, you have to. Which way you are? This side or that side?
I'm caught in between, my lord.
Yes. We'll issue notice. You
My
will
lord.
service. Yes.
let a copy be served.
We'll serve a copy.
I have not received any copy. No copy.
We'll serve a copy.
I will file.
Because he's neither on caveat, my lord,
I'm not on caveat.
nor on.
I'll be filing my wakalatnama in the course of the day, my lord. I have the wakalat.
Anyway, heard Mr. Thapa, London Council appearing for the petitioner. Issue notice. Returnable in 3 weeks. MS London PP appears for the respondent number
124, my lord.
124. And Mr. Gautam appears for respondent number 5. And hence, no formal notice is called for. You file a response. Is there any?
There is no working days, my lord. I'll file it.
You'll file objection, or you'll file written objection.
I will file my return objection.
Okay, just spread for why. Mr. Yes, we have the London Council for the respondent number 5. Weeks time is granted for filing objection in the matter. List after 3 weeks. And then come to the miss case. Hard. Just say so and so, just wait for. You can sit down, please. You can please. Why do you write notice here, petitioner notice? Why do you have addressed that the cause title thing?
Oh Lord, excuse me, I'm called to the other place.
Just take a minute, please.
It should only have been a petitioner, my lord.
Yes, so that is why this notice comes. Yes. Stop. Paragraph. This is an application seeking stay of further proceedings. What is this number? Is executive proceeding.
Yes, my lord. Executive proceeding number 2.
Proceedings in executive proceeding number 2 of 2025. You will find it at the prayer of the miskis. Initiated under section 126, isn't it? That is correct.
106 and 126.
167 and
106 is 107.
Yes, madam. 107.
Then
and-
again
and
another. Then again another question will come: whether 107 and 145 proceeding can be drawn up by this same order? Can be drawn up in one proceeding? That also another technical issue will find, because there are two differences. 145 has to be connected with the affairs of land. 107 is not. Some other technical aspects would come.
All right.
But then here it doesn't say. Okay, initiated under section 125, 126 to read with section 164 BNSS. 164 is 145. 126 is 107.
yes, sir. It is 167, my lord, not 164.
No. 167 is, my lord, under 167, the notice can be brought before the magistrate that there is
Likely.
there is a dispute involving in land or waterway, etc., which may result in breach of peace.
So
So
that is
under
one- that is-
167,
that
the
is-
petition was filed before the magistrate.
Petition was filed under.
167, my lord.
So why it is 164 written in your prayer?
My lord, proceedings are drawn under 164.
What is 164 then?
164 is equivalent to 145 of the CRPC.
So what is the difference between the 164 and 167?
No, 164 is corresponding to 145.
Yes.
And 167, my lord, talks about local inquiry.
Yes, that is a different issue.
It's a different issue. It should be read as 164, man.
Yes. Yes, that corresponds to section 148 CRPC.
Right, my lord.
So we are not connected with that.
Yes, ma'am.
Okay. What is this? This is an application.
164 and 146.
And the impugn orders dated 4/12/2025 and 10/12/2025 in the site proceeding. Stop. Paragraph. The Land Council on the petition submits that the executive magistrate has resorted to improper exercise of jurisdiction by initiating the proceeding in executive proceeding number 225 under section 126 read with 164 BNSS. in gross violation of the established norms of law. He submits that the property in relation to which the learned executive magistrate has drawn up the proceeding is the subject matter of adjudication in title suit number
But title suit number title suit number 2, my lord. 2T of 2024.
title suit number 2 within bracket T of 2024 and miss case number 30 within bracket 3 of 2025
What?
pending before
Which my miscase number is 10, man. 13 is a
30 T
30 is a later one, my lord. It is
30 is the petition
criminal
under
breach.
39
39 2A, my
2A,
lord.
breach of status.
30 is concerning 32A, man. 39 2A.
that is okay 30 T is also a part of that
Part of this.
anyway that is 30 T is also in the same
Right,
subject.
right now.
Just say title suit number so and so. Is subject matter in, just say. There are two miscases now. What is the first miscase you say?
10 T, man.
10T, my lord.
10T.
That is the one where the status quo order was
You say
passed.
the subject matter of adjudication in 10T 2025, comma, then miscase number 30T of 2025. 10T of, just like 10T of 2025 and miscase number 30T of 2025 arising out of title suit number 2 of 2025. Pending in the court of
Assistant to Deputy Commissioner, my lord.
My lord, now it is redesignated as Civil Judge Junior Division.
but then order doesn't say so.
My lord, at that point of time, it was Assistant to DC. my lord.
Pending in the court of assistant to DC, assistant to deputy commissioner. Then with that bracket you say now designated as
Civil Judge Junior.
civil judge junior
Yes,
division.
Civil Judge Junior Division.
Junior division, yes.
Junior division.
Close the bracket. River district. Nangpo. It is submitted that the learned executive magistrate, despite noticing the fact that there exist an order of status quo passed in the civil proceeding pending between the rival parties, comma, erroneously assumed his jurisdiction in the matter. In total abuse of process of law. By placing reliance on the decision of Ramsumir Puri Mahant versus State of UP, 1985, 1 SCC 427. And Amrish Tiwari versus Lalit Prasad Dubey, 2000, 4 SCC 440. These two will find. The United Council submitted it. Submits the initiation of parallel proceeding. Under section 145. During the pendency of a civil litigation. Involving the question of possession of the same property. Is barred and then stop. He therefore submit, even if it is assumed that the proceeding under section 126, read with section 164 BNSS was drawn on the assumption that there was violation of order of the civil court, comma, the same cannot be sustained in law. A prayer, comma, thus has been made to stay the proceeding of the proceeding before the executive magistrate and also the impugn order seated so and so, so and so. Just see in the first parts. So just see, MS NG Shilla, learned PP appearing for the state 6 times to obtain necessary instruction in the matter. Stop. Mr. Gautam, you have not filed your power. Will it be?
I will be filing in the course of. I have the power with me, you know.
Okay. Mr.
I will
Gautam,
be filing in the course of the day.
Mr. Gautam, Learned Counsel, appearing for the respondent number 5. Opposite party. This is opposite party, isn't it? Or respondent? What you have said?
Is a respondent, my lord, in
Respondent number 5 has vehemently opposed the prayer for intervention and submitted that the matter submitted that if there is a breach of apprehension of even if there is a
Civil suit pending. My lord, I very
apprehension of breach, huh?
I faintly remember now, my lord, there is one case, if I am not wrong, this is Jammu and Kashmir High Court.
You place it
Where
if you
they said that when there is no finding of the, this also revolved around a status quo, my lord, how the status quo was twisted. So the court said that when there is no finding of the civil court on the issue of possession, an order of status quo is passed, and if a proceeding is drawn up by the executive magistrate under 145, that proceeding is not bad in law.
anyway, just bring that.
Yes,
Bring
ma'am,
it before the court. We'll just see.
unfortunately, I don't have that with me today.
Just bring it. It is not that this interim order will is
It is only the
Will
time
be
at
there.
which this interim order is passed, my lord.
they are in perpetuity. You can get it this thing. Yes, okay.
or altered.
Okay, what you said and submits that when there is an apprehension of breach of peace and tranquility, our possession of landed property between you don't have landed property. Come on, the executive magistrate has jurisdiction to initiate proceeding under section 126 read with 164 CRPC. He submits that law and order is a subject which falls within the domain of the executive magistrate, and in that view of the matter, the interim orders, in that view of the matter, no illegality or infirmity can be attached to the withdrawal of the proceeding by the executive magistrate. And passing of the appeal orders. Stop. Stop. He, however, seeks some time to file his objection in the matter. Stop. Paragraph. Having considered the submission made by the learned counsel appearing for the parties, and on perusal of the materials of record, it appears that the learned executive magistrate, despite noticing the fact that the subject matter of dispute between the parties are pending adjudication before a civil court, and there exists an application already filed by one of the parties before the civil court alleging violation of the status quo order. What you started the learned executive ministry despite knowing the fact, isn't it? Yes. Decided to. Initiate proceeding under section 126 and 164 BNSS in the matter. Stop. Since it is a settled proposition that when a matter stands seized by a civil court, the same cannot be a subject matter of adjudication in a proceeding under section 126 and 164 BNSS. Prima facie, it appears that the petitioner has made out a case for passing of interim order. Stop. Paragraph in view of the above, it is directed that further proceeding of executive case number so and so and the operation of the impugn order dated so and so passed in the said proceeding shall remain suspended till the returnable date. List of 3 weeks.
All right.
Copy maybe is not on.
Will serve.
Do you need a judicial order to be passed?
Will serve, Malad. Since the seniors here, will serve.
I'll file the Vakalatnama before the registry. Course of the day.
Please.
All right.
Please come with that thing. You see,
Yes, madam.
this
My lord,
court
because
still strongly believes that,
my lord, that
see, just for the simple reason, we do not know whether, see, 145 is not there to punish a person for his wrongdoing. Now, what at the best court can do? Court can declare possession in favor of something.
yes, madam.
Now, can this order supersede the order passed by a civil court?
No, my lord.
That is very simple.
Civil court's
simple.
order will
Even if you
will hold the field, my lord.
even say supposing if you manage
My lord.
to get an order of possession, declaration of possession in your favor in a 145 proceeding, can it supersede that status quo order?
No, my lord. That status quo order is still
So
in
that
my
is
favor.
that is where
Because, my lord, the order of status quo does not clearly define who is in possession. So there was
That's the subject matter of the suit, Malad. That will be decided later
anyway,
on.
let us not go into we just this simple sense is that a civil court's order cannot stand negated by order of a criminal court in this kind of matter. That is what the
my lord, that is the law.
if
My
you
lord,
have something else to show, please. That will be a welcome thing for the court. Also to know.
Deeply obliged.
Please.
Obliged.
There may be some correction here there in the order.
My lord.
Daily cause list, item number 1.
Yes.
This is again that matter, Malad. We have filed for Malad, quashing of the complaint case before the learned JMFC, Malad, Shillong.
Yes.
Well, on the last date here, Malad, if you lordship recall, here, Malad, I being the owner of building, Malad, I was issued BWA in the case. Whereas I had no connections with the
Okay.
affairs of the company. my lord.
Your company was running as tenant
Yes,
in your premises.
in my premises.
Yes, Mr. Jamnath.
Your Lordship, here in this case, when we prepared this application before this CGM for compliance of the provision of the Companies Act, so Your Lordship, we have, prior to this, we have issued the notice, and in the notice, what's the address available? On the basis of the address, we have issued the notice. So, and there in the notice also it is gone to this petitioner, and petitioner didn't reply on it. Subsequently filed the CR case. So after filing the CR case, as per the record available, just we have issued the notice.
Okay, so there is no response from the petitioner.
No response.
But then now you know it.
So you will see what's happened. After that, when it was proceeding, in between petitioners come before this court and produce this agreement. This agreement. So what's happened? You will subsequently you will say just this instruction is given to take the instruction in the matters. So petitioner is not in a position to hear the matters. Why I don't know, but they are not hearing. So what's happened? You will see when this court is stated that you issue the even warrant. So as per address available, we are giving. So
So
here,
anyway, it's okay.
So-
Now it has been clarified. We can understand that
So-
you may have a reason, good reason, valid reason for issuing a process and making and then your cost title doesn't clearly show that the petitioner
is the accused. It is not so.
Okay, it is written in such a way that neither you can say that she is not a party,
Yes.
nor you can make.
No, as because in the address
Now
it is
you
given.
detect it, drop her name, that matter ends.
So you see, this was the matters. We are saying that the lower court also same thing. That whole matters, their intention is in the lower court, whole matter to be passed.
So we'll just say
No,
that
my lord. The prayer is qua the petitioner. The quashing of the complaint petition qua the petitioner, my lord. I'm not asking for the blanket quashing, my lord.
One second. See, you are alone. Nobody has been deputed in his place. So we'll do one thing, Mr. Thapa. The problem is that one of our PS has left. He has resigned from here and he has gone to join things. Don't know if we dispose it of also whether we can complete passing of order.
We can
just
dispose it
after
of after vacation, my lord.
We'll extend the stay
My
till
lord.
the date,
That is
and then we'll go for disposal on the next day. So Mr.
On the
Devnath
next
also
day.
doesn't have much objection.
right, my lord.
He is justifying his action only, nothing else.
Correct.
So we'll.
You see, in the matters, this
Or if you say that that she is not an accused and you will not, you say like
as per our this you will see here even this
Even
when
the-
we were given the notice page in that petition 27, and it is notice in the given, and then in this also after the company, her name is coming after the company. So when you were issuing that even warrant,
but then process is issued by you, isn't it?
yeah, process is been issued.
Then
Yes. So even if you go even this.
that is all right. That is all right. These are all clerical in nature.
So
say
if-
something.
So you will see even in this
If you say
master
that
data.
she is not an accused and this process issue of process is by mistake, then we record it and close the matter.
Not mistake. Then it will be required to this even
No.
directors of companies
Her
to
address doesn't-
remove her name from the company's.
No, I'm not there in the company, my lord. I'm not
Then
I'm
connected
saying
at
that
all.
she is a director of a company.
So in the record, in the company record, when the director is given,
Address is one thing, and you see, like holding the position of director is another thing.
yes.
Now, if today, if you reside in my place and give care of my thing,
So you will
will
not
I be responsible for your
No.
action?
definitely not you.
That is to be understood. And the thing is that we do not understand. You being counsel, if you have the opportunity to correct it, you should correct it. Why should you unnecessarily victimize somebody? And if you do it, then in such a case you have to pay cost. It is not a matter that you drag some aged person to a criminal proceedings for no fault. This is something
And-
it's very
and-
improper.
Petitioner is coming, and then none of the accused they are in that director.
A person has to go through trauma, shock when this is. For us, cases is a day-to-day handling, but not for ordinary person.
That-
Any person receiving a notice from court
We'll have.
will have tough time. So if you please do the thing, advise properly, make this, correct it. Or otherwise, if you still resist, then we'll pass order. And if you see if your company isn't it, so if some cost is imposed, you can pay also. There is no problem. If the situation comes to that. Anyway, we'll have it then. Okay. This is your first appearance, Mr. Devnath. You have not appeared.
Yes.
Yes, just say, Mr. Devnath Lanet. CGC has entered appearance of the respondent.
Sole respondent.
We have the sole respondent and sought for grant of some time to have necessary instruction. Prayer Lord. List after 3 weeks. Stop.
After vacation, you will see that. After vacation, that will be better.
Come
Go after vacation. 3 weeks we are just what say. After 3 weeks, this court also will not be here.
even vacation could make all this.
Yes. Make it list after vacation. Okay. He will be not under any tension. The interim order, if any, passed earlier, shall continue until further order. Yes.
Deeply obliged.
2,
This interim order was passed in a miscase or in the same?
In the same case, madam, we had made a prayer.
Yes.
Item 2 and 3 are connected, madam.
You will see maintain only for the.
2 and 3 same orders.
In the next returnable date, you will see better. Interim order to be that next date. It will be better. Otherwise, they will not appear. You will
This is a
see.
case.
No question of we not
Do you have any
appearing.
doubt about the merit of the petitioner's case?
So you will see. No, you will see because of it.
Anyway, okay. Just interim order shall continue till the return date. Yes.
Because
no
petition will be effective.
See, in such a case, if it is not taken up on the next day, then it again has to be extended on a piecemeal basis. No problem. All right.
Because you will see the others, these directors, they are taking advantage, but they are not coming. And the petitioner is coming and then she is giving the
Court
agreement.
is maintaining a balance between two, so it is still returnable date.
Obliged.
hearing item number 4.
Yes.
Lordship, this matter, Lordship, I'm praying if it can be taken after vacation, Lordship.
What is this matter about?
Your Lordship, this is that matter regarding the DGFT foreign trade, Lordship, where we are supposed to pay some amount to the, in return of trade, we are supposed to pay some amount to the DGFT, Lordship. But because of this prevailing situation, we could not pay. So thereafter, Lordship, we had written various representation to the concerned authority, and they have not responded to that, Lordship. To that effect, Lordship, we have come before this court.
Okay, so there is a liability on you to make some payment.
There is a policy by the central government, exim policy, export-import policy, whereby, my lord, if I am unable to maintain certain
Trade,
export, trade or commerce, my lord, then in that case some liabilities are imposed on me.
Okay.
But my lord, here there are circumstances, but of course there is a provision that I can make an application giving the reason why I could not maintain that. And my lord, on the basis of those representation, of course the department concerned can look into it favorably.
Waive the thing.
That was done, my lord, they have not responded to it.
Okay. But then can you claim it as a matter of right?
Not exactly, my lord, but it is provided under the policy that they can consider.
So they have not even responded to
No.
it. That is something improper, isn't it? If they do not accept your prayer, they should reject.
Yes.
Yes.
Your Lordship, this matter may come up after vacations, Your Lordship.
We thought you were ready with the hearing.
Your Lordship, actually, Your Lordship, apologize, the DSGI is on legs before.
Actually, you knew that what would happen from the other side.
No, Your Lordship, we were ready.
There was
Your
a
Lordship.
discussion in the corridor outside the courtroom. Okay.
Your Lordship, we were ready.
On joint request made by the parties. This is matter after election.
Sir.
Much obliged.
Item number 5.
Yes.
May please, Your Lordship. Lordship, can you have the matter after vacation, my lord, since the conducting counsel is on next, my lord, before court number 3.
This is a matter when the respondent has not appeared,
Lordship.
despite service of notice.
Lordship.
There is with regard to that vehicle seized
Vehicle
in
been
connection
seized.
with forest under the forest.
Grant Zema, my lord. The district session judge has granted Zema to the
Yes,
regards
granted.
that vehicle. Being revider will be before your lordship.
Okay. On prayer made by Mr. Ranja Lorenzi, appearing for the petitioner, this is matter of application.
Evening.
And we put a requisition for sending urgent